this is Trey Wilson, San Antonio evictionlawyer.com, and I just got a quick video here to give some clarification to my property manager and landlord friends about delivery of notices to vacate. We've been getting an influx of calls and questions lately about defects in delivery of the notices, and I wanted to clarify the issue and make sure that there's a better understanding of what the law says about the method of delivery of the notice to vacate. We all know that section 24.005 of the Texas Property Code requires a notice to vacate to be delivered 3 days before an eviction suit can be filed. And that's pretty cut and dry. The real question comes into what is the proper method or manner of delivery of the notice to vacate. And I've seen lots of confusion on that issue lately, not only by property managers and landlords themselves, but even by professional process servers and the Bexar County constables. Section 24.005F declares that there's two default methods of delivering a notice to vacate. The first method is by personal delivery of the notice to vacate to a person or to the property. Delivery to a person is handing a copy of the notice to any person at the property who's over 16 years of age, whether or not they're a listed tenant on the lease. The second method of delivering the notice to vacate that's acceptable under the Texas Property Code is by affixing a copy of the notice to the inside of the door of the premises. And there seems to be a whole lot of confusion about that. Taping the notice to the outside of the door is insufficient. It seems to be happening over and over, and so I looked back at the statute and asked where did that confusion seem to come from, because there's a wide misconception that taping the notice to the outside of the door is good enough. Well, it turns out that the legislature recently made revisions to section 24.005F1, and that section does allow delivery of the notice to vacate to the property and taping it to the outside door under very limited and defined circumstances. And I want to visit about those circumstances today. Okay, so section 24.005F1, which is the culprit for causing confusion about when it's appropriate to tape the notice to vacate to the outside door, is very clear in its language. It provides for two distinct circumstances in which taping to the outside of the door is sufficient. The first of those circumstances is when the person delivering the notice to vacate has determined that there's a reasonable belief that there will be harm to a person by affixing the notice to the inside of the door. That reasonable belief generally is based upon the presence of vicious animals, potentially violent situation with the tenant, or some other sort of reasonable belief that there's a danger associated with going into the premises, notwithstanding the fact that the landlord has a key and has contractual access to the premises under the lease. The second circumstance in which taping the notice to the outside of the door is permissible is when the premises doesn't have a keyed entry lock. In other words, there's a deadbolt that locks only from the inside, when there's no mailbox present, or when there's an alarm system that would be set off by the landlord or person delivering the notice to vacate, opening the front door to the property. So lately I've detected a lot of confusion about not only when it's appropriate to post the notice to vacate to the outside of the door, but also how it's legally permissible to perform that function. This is what happens more often than not in the cases that hit my desk. The landlord or person delivering the notice will tape the notice to the outside of the door, and they'll leave it there. Sometimes they're astute enough to even take a picture to prove that the notice has been taped to the outside of the door. Unfortunately, that is not good enough under section 24.005F1. The statute very clearly says that if the notice is going to be taped to the outside of the door, then the notice has to be placed inside an envelope, and that envelope has to contain the words important papers and also the tenant's name, and the envelope has to be posted to the outside of the door. In addition to posting the envelope to the outside of the door, the notice to vacate has to be mailed to the premises on the same day that the notice is posted. So just to make things clear, envelope, containing the words important papers with the tenant's name posted on the outside of the door, sufficient. Simply posting the notice to vacate to the outside of the door, even if there's a picture and an affidavit saying that happened, is insufficient. Delivery of a notice to vacate is jurisdictional if that notice is not properly delivered and there's not clear evidence of the manner of delivery. In compliance with section 24.005, the court will dismiss the eviction suit, and more often than not, they'll assess attorney's fees against the landlord.